Yes. Family pension matter of 2021, my lord. Can I pray for listing in the next week?
Next week,
Family pension matter.
17th?
17.
Okay, for listing of this writ petition on last 10/9, it was notice was issued. Returnable by 4.
17th.
Math.
Well, I am praying for a withdrawal of a writ petition on Wednesday. But
Tomorrow?
tomorrow I have some document.
All right, Wednesday.
I beg to mention item number 24, Lordship, 24.
Yes.
Order is complied with Lordship. Lordship may discover.
Who's for the respondent? You're for the petitioner.
Petition orders.
Look in counsel for the petitioner on instruction submits that the directions comply contained in the order dated so and so, past in WPC so and so, has since been complied with. So taking into consideration the submissions made, this court does not wish to proceed with the writ petition any further, contempt petition any further. Accordingly, same stands closed. Notices issued are recorded. Disposed.
May I please, Your Lordship?
Yes.
I have filed a writ petition on 31st 10, my lord, and the matter is related to selection and appointment. The process will over on 14th, my lord. But kindly,
Why is it not listed?
we have no idea, my
You
lord.
go and get your ideas from the registry. Why it is not listed?
We went there, my lord. We went there. They have asked to mention it, my lord.
Who has asked you to mention it?
From filing, my lord.
All right, on 12th,
Obliged, my lord.
subject to clearance of defects.
Obliged, my lord.
It will check for you, mention for you. Huh? Routine of it to I will check for you. Yes.
May I pray for listing of a matter, my lord, transfer matter, my lord.
Transfer matter.
Transfer matter.
19th.
Obliged, my lord. Obliged, my lord.
Yes.
Please, your lordship, I beg to mention item number 20.
20.
20.
20.
Yes, lordship. In this
Yeah.
matter, we need some time to file affidavit in reply, lordship.
You're for the petitioner.
Yes, lordship.
Item 20. And the request made by the council for petitioner stands deferred to the listed after previous.
May I please, Your Lordship?
Yeah.
First, I beg to mention for listing of a writ petition for admission column, my lord.
Admission. For 19th.
Much obliged, my lord.
May I please, your lordship, in item number 28, we have filed affidavit in opposition on Friday, lordship. But the affidavit in opposition is not in record, lordship. The record may be called for, lordship.
28.
Yes.
All right, the matter be listed on 14th of November. It is submitted by the counsel for the petitioner that an affidavit in reply.
Yes, affidavit in opposition, lordship.
Opposition.
Yes.
The affidavit in opposition has been filed. The registry will trace out and connect the same with the case record. Who's for the petitioner?
Mr. T. Devi is there, lordship.
All right.
Much obliged, lordship.
May I please, your lordship, I beg to mention for listing of the matter regarding selection and appointment of Gavura lordship. Lordship, it was last posted on 13/6/2025. Can it be on 12, lordship? Wednesday?
Not 12, 19th.
Hello, civil affairs, which matter, my lord?
19th.
And that I also beg to mention for listing on admission matter. Pension matter, pension has not been given.
Pension matter. Pension matter, all right, on 12th.
I'm deeply.
With regard to item 21, lordship, I have instructions to withdraw this matter with liberty, lordship.
Item 21 on instructions received by the counsel for the petitioner. That the writ petitioner does not wish to proceed in the writ petition any further, seeks the liberty to withdraw. Stop quoting me.
Oh,
Prayer made is allowed, writ petition dismissed on withdrawal with liberty. Interim orders, if any, stand vacated. Pending ayes are also discussed.
I am for accounting general.
Mr. R. Borough is for accountant general. Then who is for agriculture?
B Chaudhary used to appear.
Mr. B. Chaudhary. B. Chaudhary for agriculture department.
May please your lordship, here for listing.
Yeah. Listing of what?
Writ
Writ petition.
petition, WBC.
See. 24th November.
I have another objection.
Listing for
Listing
what?
for two.
For admission?
Admission.
Admission, all right. 24th November.
Lordship, I beg to mention a writ petition or motion which is last.
24th November.
Not, sir, again, Lordship, it's filed on 6/11/2025 matter.
New matter.
New matter,
New matter.
new matter.
6/11 you file. 6/11 you file, it will come.
Lordship, kindly stay on tomorrow or day after tomorrow.
Fresh matter, all right. 12th.
Sir, Lordship, matter related to.
12 November.
May I please? Your lordship, I beg to mention for listing lordship, newly filed lordship,
When did you file it?
on 30 lordship,
On?
on 30/10, your lordship.
All right, on 12th.
May please. Is it contempt proceeding lordship?
Where is that order?
Our lordship, relevant portion lordship will get at page 163. Lord. 163 lordship.
163.
Lordship. Paragraph number 18 lordship. This number got directed to pay the area remuneration to the female
In
attendant.
2017,
Lordship,
then
Lordship, thereafter, Lordship, a series of contempt proceeding, Lordship. Lordship's order may kindly peruse, Lordship. Page 169, Lordship. Government has sanctioned already and Lordship, subsequently, Lordship, this case, a series of litigations have been closed by this honorable court. Sir, as those are, payment has already been disbursed, Lordship. Lordship, one order may kindly.
no, but you are filing a contempt
Lordship.
in respect of an
on-
order passed in 2017.
Lordship, page 170, Lordship, this is the new case of 2025, Lordship, and this honorable court issued notice on 18th of February, Lordship. 18th of February 2025. Let the matter also come with this contempt, Lordship. Page 170, Lordship.
170.
170.
But
another fact,
whether
Lordship. A series of similarly situated contempt listed on 18 February.
Right, then
Lordship.
let this, it is submitted that similar content petitions are filed alleging willful disobedience of the directions contained in the order dated 23/10/2017 passed in WPC 900/2013. So one of the matters being contempt case number 22 of 2025, where notices are issued. So why do you say 18 February?
Lordship, 172, Lordship, page number.
There is no date fixed. It says only 8 weeks.
No date fixed, but notice was issued on 18th of February. I'm sorry, Lordship.
Notices were issued. Let this matter also be listed along with contempt case 22 of 2025. The question of issuance of notice in the matter will be considered on the next date, as this petition is filed alleging willful disobedience of directions contained in an order passed in the year 2017. The contempt case has been filed in the year 25, alleging willful disobedience of the directions contained in an order passed in the year 2017. Please take accordingly.
Obliged.
Lordship, non-compliance of order dated 17/6/25, my. Operative part, page 1616, paragraph 28. my. That is, the appellate authority shall decide the matter afresh within a period of 30 days from the date of receipt of the certified copy of this order and shall pass appropriate order. While deciding, the appellate shall also consider aspect of proportionality of the punishment imposed on the petitioner. Thereafter, certified copy is furnished before the.
Counsel for party, the petitioner issue notice, returnable 4 weeks. Steps on respondents by speed post within 1 week from today. List after the returnable date.
Obliged.
Item 3. Item 3 lordships, one instruction I have received, my lord, that the department has asked the consent of the petitioner, then the second appellate authority, they want to transfer this matter to the second appellate authority. lordship. It was given to the my lord, that petitioners. lordship.
Yes, have you received it?
Yes, ma'am.
Ah,
So, my lord, the matter may be disposed of with a direction to dispose my appeal within a.
have you seen
Specific
this
time.
letter?
Well, they have received, I think.
Have you seen this?
Yes,
So
I have concern, ma'am,
you have consent for what?
for disposing of the matter to some other authority.
Other authority,
Yes,
but you lose one forum. You will lose one forum. Therefore, I am asking you, have you seen this letter?
My lord, even then, my lord, first appellate authority director, the director cannot taken up his matter as because at that time, my lord, he was the my lord, deputy commissioner.
That is all right. Even the
All right.
director is conscious that you will lose a forum.
That's why this.
You get your instructions.
My lord.
List day after tomorrow. Enabling the counsel for the petitioner to obtain required instructions. You want it day after or next week?
day after tomorrow, ma'am.
Day after two. On the communication dated
27/10/25.
27/10/2025, issued to the petitioner from the office of the Director of Land Records and Service.
My lord, next week may be fixed.
17th.
My lord, I am obliged.
I appear for 3 and 4.
Mr. J. Hendick for Revenue, Mr. D. Bora for
3 and 4.
3 and 4.
May I please? My lord, by order dated, my lord, 22/10/2025, instruction was sought for.
Yes, who's for the respondent here?
Lordship, Mr. T.C. Sutia, he is on legs in court number 19. Your lordship may take it after some time. I'll just call him in. lordship.
After some time.
Brief is.
Bye.
May it please, your lord. See, lordship, this is in regard to, my lord, non-payment of compassionate family pension as well as family pension. money. The last date, my lord, instruction was sought for.
Yes, I have received one communication where it stated that next of kin certificate has not submitted before the concerned authority, lordship. May I place for lordship?
You give him a copy. You communicate.
My lord,
Some next of kin certificate is not there.
my lord, this is a, my lord, Muslim, my lord, law, my lord. As per, my lord, the family is a Muslim family, my lord, and here, my lord, the family defines, my lord, the wife of the, my lord,
Yes.
employee, my.
Your which wife? How many, your which number wife?
My lord, I am the only wife, my lord,
Only wife.
only wife. And my lord, the problem is that, my lord, after the death of my husband, immediately after the death of my husband, my lord, his brothers and others, my lord, they went for obtaining an, my lord, next of kin certificate, my lord. And thereafter, my lord, next of kin certificate was procured. And thereafter, when I made an application, I have come to know that
Your name is not there.
my name was not there. Therefore, my lord, I have made an application there. And subsequently, that next of kin was revoke, my lord.
Ah.
And my lord, in spite of my repeated requests, my lord, they are not issuing any, my lord, next of kin certificate. And otherwise,
Then you have remedies in law. Without the next of kin certificate, how will the process?
but my lord,
Cannot.
but my lord, as per my lord, this my lord, 148, my lord.
Hmm.
My lord, on receiving, my lord, information of death of an officer while in service, the administrative authority will send a letter to the prescribed in Form 9 to the family of the deceased. Ask for necessary formal application in Form number 10. But my lord, that was also not communicated to me. No response, my lord, nothing. My lord, in spite of my repeated requests, my lord, my representations, my lord.
Lordship, they have not denied. They are ready to forward it because of lapse of this relevant document. It is very clearly stated in my communication.
Because, my lord, I am the married wife and I have enclosed the, my lord, marriage certificate, my lord. So unless and until, my lord, this is, my lord, this is a valid marriage certificate. So without, they could have, my lord, proceed with, my lord, on the basis of this marriage certificate.
Not how it is done. What is your difficulty in giving the next of kin certificate?
Data from Jackson Mabla PCTS. Data from Jackson. Next to kin certificate DCA issue করবো DCA direction দিয়ে learner. DCA party বানাইছেন রেগুলেশন পার্টি আছে না
She is not the party.
This is death in service or
Death in service.
death while in service?
Yes. My lord, I have approached and I have even I have issued one 80 CPC notice also, my lord, regarding, my lord.
But why are you not pursuing the next of kin certificate?
DC will give DC party
That will clear all the cloud.
where party
My lord, my lord, let him file an affidavit, my lord.
what party
About what?
My lord, bringing on this, my lord. Or, my lord, I may be given some
next
time to, my lord, obtain some instructions.
next to kin certificate will be issued by the DC. I think. Next to kin certificate দেয়া নেই। Next to kin তো লাগিব ন কোনো স্টেটমেন্টও নাই যে নেক্সট টু kin নাই নাই দিয়া নাই দিয়া
Where is the Form 10?
My lord,
Form 10.
Form 10, my lord, I have not enclosed.
Then what particulars does it contain? Assuming they are directed to issue a Form 9, you have to reply in Form 10.
Yes, my lord.
So where is that Form 10?
My lord, Form 10, my lord, form of application for family pension, my lord.
So where is that Form 10? Do you have a copy?
My lord, I have not applied in, my lord, in this format, my lord. Because, my lord, I have not given, my lord, as, my lord, any, my lord, issue of notice as per, my lord, Form 9. She being an illiterate, my lord, she is not know about this. Therefore, my lord, she made an representation, my lord. Instead of making it in as per, my lord, Form 10, my lord, she made her representation.
Have you applied for pension?
Yes, yes, my lord. I have made my representation, my lord. Several representation. I have enclosed it. Annexure 3 and 4, my lord, my representation, my lord. Also, I have, my lord, applied for, my lord, furnishing the copies of, my lord, service book, service sheet. And, my lord, even I, if, my lord, and also, my lord, I have sought for, my lord, furnish me the name of the nominee recorded in his service book, right? That was also not furnished, my lord.
You apply for the next of kin certificate and furnish it.
My lord, next of kin certificate, my lord. Lord, what had happened, my lord, when I, my lord, made the, for NOK, my lord. Then I made for next of kin certificate, my lord. Then, my lord, the earlier one, my lord, which was issued in favor of, my lord, brothers and, my lord, nephews of the, my lord, deceased, my lord, employee. My lord, there, my lord, the chairperson, as chairperson SDM Titabor, my lord, after hearing, my lord, NOK reverted in case of legal errors from SDO civil office will continue to remain reverted. SDO civil is not the competent authority to decide the validity of marriage and the documents procured therewith. And thereby SDO civil office is not a competent court to decide the matter of legal error in this case.
Whose name is there in the nominee?
Yes, ma'am. At least that, if I got that information.
Lordship, this is in the service book,
So
maybe.
let us in-
Service book is maintained by, in the gazetted post, service book is maintained by Accountant General, not the authority. In gazetted post.
How is it maintained by the accountant general?
Yes, Lord.
How it will be, because Form 10 is been some, my lord.
You are the administrative department.
Service book, as per my telephonic instruction, Lordship, they said that.
Did he superannuate it? After, did he expire after retirement? Or he expired during service?
During service.
During service,
Lordship
Lordship.
may
But
produce page 25.
Yes.
Clearly it is mentioned. Who is maintaining?
25.
Page
My lord,
25, annexure 8, my lord. My lord, this is in response to my RTA application.
We have clearly mentioned, making reference to your RTA application dated so and so, received this of the.
It can't be maintained by accountant general. How can it be?
The book is not maintained by
Somebody
this
has not
office.
given you correct instructions.
Clearly, we have written, my lord, to him, it is not maintained by this office. This office means our office, that is AG.
Last pay certificate is issued by the concerned DD of the department. Further, the demise of Dr. Ahmed Habiur Rahman has not been intimated to this office.
Yes, that is to be
Hence,
by
this,
department.
hence this office is not in a position to provide you the information as sought for.
this is public information officer.
Ten is essential because, my lord, presently it will be not required. There is a family pension in case of issue, unfortunately.
Please get the instructions.
Yes, Lordship, on that part I will take instruction.
Service book is maintained by the, you are appearing for the health department.
Yes,
It has to be maintained by the health department.
Definitely, well, I have part time, lord.
It has to be maintained by health department.
That was telephonic instruction that in the gazetted post. area.
That was with
Okay, Lordship, I'll.
payslip, my lord.
Counsel for the petitioner submits that the claim of family pension in respect of a deceased husband has not been released by the department. Therefore, the present petition has been filed. There are pursuant to the order dated 29/10/25, MS S. Sharma, Standing Counsel Health Department, has placed before the court the communication whereby the department has sought for the next of kin certificate
Next of kin.
from the petitioner, which has not been submitted. Therefore, the family pension, the family pension, the claim of family pension by the petitioner has not been processed. Whereas Mr. M. Doctor, counsel for the petitioner, submits that earlier the next of kin certificate was issued by the office of circle officer,
SDO civil,
by the SDO civil Titapur, in favor of the brothers and nephew of the deceased, of a husband of the petitioner. And on a complaint made by the petitioner, the same was revoked. No fresh next of kin certificate has yet been issued by the deputy commissioner, concerned deputy commissioner. So, Mr. Doctor, on the other hand, has referred to section 148.
Yes, ma'am.
To submit that the department is required to inform the petitioner upon the death of the government servant requesting for a formal application to claim the pension. So it is submitted that said communications were never issued to the petitioner. So yeah, upon considering the submissions made, this court requested that the court sought for the information as to the nominee within quotes, if any, mentioned in the service book of the petitioner. Stop. MSS Sharma, learned standing counsel, submits that she will have to obtain instructions on this. Accordingly, let this matter be listed again on
Lordship.
November.
My name is
Mr. C. Borua,
person number nine.
learned counsel, appears for accountant general, Mr. D. Bora for
For number one.
respondent number 1. Is
Okay.
accordingly on 28.
Obliged.
I can see. That's.
That's why I have received instruction, Lordship. As per the instruction, Lordship, several opportunities was given to the petitioner to improve his conduct, Lordship. Despite this, he has failed to maintain his work performance, Lordship. So due to this, as per contract agreement, he has been terminated from the service, Lordship.
Is the agreement here?
Yes, my sister. Page
Page-
17, madam.
Page
Page 17, madam.
17.
Madam. The contract duration shall be for a minimum period of 1 year to be reviewed and renewed based on review of performance and work requirement. I have not completed 1 year, madam. And madam, that fourth clause Notwithstanding anything contained herein above, your service may be terminated at any time if you are found to be guilty of insubordination, intemperance, and other misconduct of any breach or non-performance. We have so cause earlier. I have annexed the so cause also. Page 21. Page 21.
You are not covered by the 64 rules.
64.
Not 64 rules. But even if I am a temporary servant minor, they have to issue a notice before termination.
They have given you a
So cause,
suppose.
yes.
So cause I have replied that thereafter, my lord, I was warned. My reply, thus will find the so cause at page 21. And my reply is at page 22. And the punishment they have imposed at page 24.
No, this is warning letter. 24 page warning letter.
Is also a kind of punishment.
A sums was given by page 24. That's it.
This was on 3/6/2025. But before issuing the impugned order at page 25, no so cause was issued. And this order is a stigmatic order, my lord. If your lordship, there is the order, impugned order at page 25.
No, but this is a contract employment.
Yes, yes. I admit.
So
that,
you
my
have,
lord.
you have,
Contract period was for 1 year.
1
year. I have not completed the period of 1 year. Had I been terminated after had my contract been not continued after 1 year?
No, under what provision are you demanding that there has to be? It is not a case that you are suddenly terminated. You give an opportunity, so cause, reply,
Warning
warning.
letter.
Yes, that's true. That is true. But before issuing the impugned order, my lord,
How does it,
no notice was.
how does it affect you? Unless you say that after the warning, you had improved or you continued to render your service, which was considered to be within acceptable norms. Therefore, there was
My
no
lord,
question
even
of.
if I have improved, my lord, if the officers are, my lord, hostile to the petitioner, they will
It's
never.
a matter of evidence, Mr.
Yes.
Swakia.
My lord.
It's a matter of evidence.
My lord, if this order is a stigmatic order, my lord, they should have issued a so cause.
You have other forums, you can go
Yeah.
and file the matter before other forums. For a writ, there must be a responsibility imposed upon the authority to show that they have willfully or they have neglected to.
I have stated that in my petition, my lord. That I have done my duty as per the instruction of the authorities. And my lord, there is
No,
no.
according to you, you have rendered service up to the desired level.
My lord.
According to the authorities, not up to the desired level.
Yes, yes.
What basis will the court decide?
My lord, in terms of the contract agreement, my lord, they should have allowed me to complete the 1 year of service.
No.
At least.
How many years have you completed?
I have, my lord, 8 months, 8 months, my lord,
8 months.
my lord.
So which provision of the contract?
Clause 1, my lord. The contract duration shall be for a
Minimum.
minimum period of 1 year. So, my lord, if my performance was not good.
Then you come to
Clause 5.
number 4.
Yes, yes, my lord.
4 and 5.
Number 4 is there.
Yes, my number 4 is there, my lord, and the 5 is either party
No,
may
no,
terminate
four.
the contract at any time upon 15 days notice.
Yeah,
That is also not given
not notice
with
was given?
termination.
No, but what about number 4?
Yes, 4 is there, my lord. 4 is there. Have read that, my lord. Or
So
misconduct.
4 has to be read independently.
Yes, ma'am.
So if 4 is read independently, 5 does not come into play.
And for applying 4, my lord, they have to follow the 5 also, man.
No. 4 has to be applied independently, notwithstanding anything contained.
Yes, in the above, my lord, not below.
We don't find any merit.
At least a notice should have been issued, my lord.
How does it affect you?
Because
On
it's
what basis?
stigmatic order, my lord, stigmatic order. I should have been allowed to, my lord, explain
You file
my
an application,
position, my
seek a review, we can permit you that. Beyond that, we can't, we cannot sit in appeal without any evidence being there. Or you want us to take evidence? Then what orders can we pass? Is the right
Possibly grant the petitioner to seek review of report of authority.
for the petitioner and Mr. S. Doctor appearing for the revenue department, the petitioner was appointed as a accountant under the Assam State Disaster Management Authority. Within bracket AIR, B for Bombay, MP, B for Punjab, World Bank Project. Stop. Petitioner was engaged in service on which date? 17/1.
16/1/2025, my lord.
16/1/2025, and he joined in his service on 17/1/2025. So thereafter, the petitioner, after rendering about 8 months of service, was issued a show cause notice on 21/5. No, not 8 months. After about 4 months, issued a show cause notice dated 24/5/2025. Calling upon the petitioner to show cause as to why disciplinary action shall not be initiated against the petitioner for willful negligence of the duties in respect to the areas mentioned in the show cause notice. So petitioner submitted his reply on 26/5/2024, explaining that there was no deficiency in rendering his service. So thereafter, on 3/6/2025, petitioner was issued a written warning for performance improvement. So thereafter, the petitioner continued to render service when he was served with termination order dated 6/10/2025. Stop. There. Learned counsel for the petitioner submits that in terms of the agreement, the petitioner is required to be served with a 15 days written notice to the other in case of the authorities taking a decision to terminate the petition. So, Mr. S. Doctor on the other end submits the learned counsel for the petitioner therefore submits that the impugned termination order be interfered with, has no opportunity of proper hearing, and notice prior to termination, as is required in the as per the contract agreement, was furnished to the petitioner. So, upon being permitted, Mr. S. Doctor, counsel for the respondent, obtained his instructions. Stop. Mr. Doctor submits that in terms of the agreement, the department is empowered to take disciplinary actions. Stop. The petitioner has been found to be negligent in performing his duties and lacking the basic knowledge to perform the job responsibility of an accountant. Stop. Further, he was found to be repeatedly failing to meet the minimum standards of diligence, discipline, and responsibility expected from his position, and as well as he was found to have resulted to insubordination. Stop. It was also found that there was repeated delay in processing payments without any appropriate explanation, despite multiple follow-ups and urgency of financial timelines. He was not able to provide adequate or timely responses and was found to be absent from internal and external meetings. So under these circumstances, the petitioner was terminated, as the contract agreement provides for a clause for termination of the same. So the claim of the petitioner that he was not given a notice prior to termination appears to be incorrect. Stop. Petitioner was given a show cause, to which he had replied. The only claim of the petitioner is that his termination was not preceded by a 15-day notice. So there is no dispute that the petitioner is not employed in government service. He is employed on contract basis under the so-and-so project. And the terms of appointment are governed by the terms of engagement are governed by the contract executed by and between the petitioner and the respondent authority. And the conditions are not disputed by the petitioner. The only ground urged before this court by the petitioner is that the 15-day notice, written notice prior to termination, was not complied with. Stop. Considering the submissions made and the terms of engagement, perusal of the terms of engagement, it is seen that the entire period of contract was for a duration of 1 year. And the contract agreement clearly specifies that the services may be terminated at any time if the employee is found to be guilty of insubordination, intemperance, or other misconduct of any breach or non-performance. So, the allegations made by the petitioner against the petitioner and in the show cause and the replies thereto are issues which will require determination on facts. So no materials have been placed either by the petitioner or by the respondent, which will enable the court to decide the question of the correctness of the allegations made against the petitioner at this stage. Stop. The question of absence of prior notice also cannot be entirely accepted in view of the fact that a formal show cause was issued, was served on the petitioner, and he had submitted his reply. Stop, warning letter was also issued. So, however, it is the grievance of the petitioner that prior to termination of the contract, 15 working days written notice to the writ petitioner was not issued. Stop. This condition of the this condition mentioned in the engagement of issuance of 15-day working notice, according to this court, may not be applicable in a case where the services are terminated if the employee is found to be guilty of insubordination, intemperance, or other misconduct or breach or non-performance of the contract. Stop. While in the case of any violation of natural justice, the writ court is certainly empowered to issue appropriate orders. However, the facts narrated in before this court in the present proceedings does not reflect that there was a complete violation of natural justice. So the opportunity was found to be granted to the writ petitioner, and to which the petitioner had also responded. So whether the response of the writ petitioner ought to have been considered by the employee, or whether the allegations made by the employer against the writ petitioner have been are found to be not based on facts or materials, are questions which are questions of fact which cannot be decided by this court in the absence of adequate materials before the court. So, under such circumstances, this court in the present proceedings is not inclined to invoke its powers under Article 226 as prayed for. The writ petition, therefore, being found to be devoid of merit in respect of seeking orders from the court, the same is hereby dismissed. So the dismissal, however, will not preclude the writ petitioner to take recourse to appropriate forums if the petitioner is advised to pursue his remedy. Writ petition closed in terms of the above.
Item 7.
May I please, Your Lordship? Lordship, matter relates to selection and appointment of the Anganwadi worker. And after the release of the advertisement, the petitioner accordingly applied for the interview, which was held on 8/1 of 2025, and the results were declared in the month of May, Lordship. After that, after the main results were declared, another result were declared on 12/8, and accordingly, respondent number 7 was selected after that, Lordship. And she joined on 14/8.
Get your instructions here.
Lordship,
This is for BTC.
BTC, my lord.
The heard counsel for parties. At this stage, the court permits the standing counsel, BTC, to complete her instructions in the matter. Let the matter be listed again after 3 weeks.
My lord, let notice go.
Notice be issued, my lord, yes.
Hmm,
Notice be issued.
Why? Get instructions first, satisfy us.
Because my lord, the thing is that already somebody is appointed. Once without notice, my lord, she won't be heard, my lord.
First, let us hear you.
Yes.
Let us first hear you to find out what do you have to say. But you want a notice, all right, then we'll issue a notice. Our council for parties issue notice, return ago 4 weeks. Mr.
I have
Or-
prepared for 1 and 2, my lord.
appears for 1 and 2.
My lord.
Ms. Borua appears for
3, 4, 5, and 6.
3, 4, 5, and 6. Since the respondents are represented by the councils, respondents 1 to 7, represented by the council. Notices are waived, extra copies will furnish.
Lordship, 7 will be the private respondent.
1 to 6, notices are waived. Extra copies will furnish within a period of 1 week from today. Steps on respondent 7 by raised speed post within 1 week from today. List after return to the.
Lordship, pendency of the writ petition, sorry.
You are challenging the appointment. Where is
Yeah.
the question of pendency now? The respondent 7 is appointed,
Yes, Lordship.
then you are challenging her appointment order.
Correct.
You are challenging her appointment
Yes,
order,
Lordship. Yes.
which can only be decided by the court.
Obliged.
Obliged, Lordship.
Second way,
May I please, Your Lordship. Lordship, the petitioner earlier approached this honorable court because, my lord, he had applied for a post of fireman. And he was not considered holding that his driving license was a fake one. Therefore, he approached before this honorable court, and this, your lordship has decided the case in his favor and directing the respondents to consider his case within 1 year, any vacancy that may arise. Thereafter, they have filed a review petition, my lord.
Who filed?
The respondent, my lord. And that was also dismissed, my lord. Now, after dismissal, they have decided that there was a no vacancy. The period held determined by the writ petition, my lord. By the order of the writ petition. And thereafter, he filed application under RTI, how many posts were vacant, but they did not reply to that, my lord.
Then you have to file an appeal before the appellate authority.
But appellate authority, it was, my lord, filed.
Then
They have said that it is related to intelligence and security related person, reasons. That is why they did
there
not.
is a further appellate authority.
Well, and that one more point of, when they did not decide as per the order of the writ petition, they have filed a review. My lord, so in my humble submission, from the date of review, my lord, because the order of writ petition has merged with, my lord, review petition.
Yes.
Let me have the instruction, Lordship. Or Lordship notice me.
My lord, because a notice be issued, my lord, because they have to disclose that how many posts were vacant at that period, my lord.
But you had pursued under RTI.
RTI also, my lord, how many, but they did not.
So if they
Reply.
did not, then there are
Appellate for.
forums for redressing your grievance. Why have we not gone there?
But my lord, by that question, my
We are
lord,
not an RTI authority.
yeah, when they have filed an review, my lord, whether that 1 year,
Whether it is there or not, you have already gone before the authorities under RTI.
they are,
If they have not granted, then we are not here to. We are not an authority in lieu of the authority under RTI.
but the question relating to filing of review petition, whether extended time or not, that is to be,
That
Determined.
you are not, this is not a contempt petition.
Yes.
my lord.
This is not a contempt proceedings.
No, the review petition has been filed by them, my lord.
You are saying, your contention is that in spite of the direction given by the court,
My lord,
they did not comply with the order. Rather, they filed a review petition.
review petition, my lord.
So therefore, by filing a review petition, they extended the time.
My lord, because they did not
So
decide,
according to you, the order of the writ court was not complied with. Is that your case?
my lord, later on they have decided.
Within the time frame? Is there a direction here? Where is the direction?
Yes,
here?
direction, my lord, that is at page,
Within 1 year.
within your name, that.
Hmm.
At page 32, my lord, paragraph 8.
After that, after the order of review, what order was passed?
My lord, that is at page 41, my lord.
So they have already said that your vacancy is not there. Page
My-
43.
My lord,
Then
now my, well, if the, my lord, to the information of the petitioner, 4 posts are vacant, my lord.
why,
If-
how did
if-
you get this information? From where?
My
What
lord,
source?
that is informal, that is why he
Huh?
filed.
So on what basis do you want us to say that statement made in page 43,
My
para
lord,
6
my lord,
is incorrect? This is your case. Statement at para 6, page 43 is incorrect on facts.
my lord, that is why I have filed RTI.
Ah.
They have not replied.
So
But my lord, suppose, even if, my lord, on 39/2024, review was dismissed, and from that, if it is counted, my lord, 1 year, then he may fall, my lord. He may get any vacant post. That is my lord submission.
So who will make that inquiry? You want the court to make that inquiry on your behalf. You have to tell us that yes, there is vacant post available, yet they did not consider us, did not consider you.
I have made,
You have made an attempt to find out whether they were vacant posts. They have not disclosed. So therefore you have come to court seeking a direction that this information should be disclosed, so that you can decide whether to proceed further or not. You must first be in possession of information that there were vacant posts available, and they deliberately did not consider your case.
informal information is that 4 posts are
We
there.
can't act on informal information.
My lord.
We will not act on informal information. You find out, you get your instructions.
My lord.
Mr. S. Sahu, counsel for the petitioner. Mr. S. Roy, Ballot CVC appearance for the states. Petitioner is agreed by his, by rejection of his prayer made before the authorities concerned for being considered for appointment to the post of a fireman in the Fireman where?
My lord, research, aviation research center,
Aviation Research Center. Where is that?
Dumduma,
Dumduma,
Tinsukia.
in the district of Tinsukia. The petitioner had earlier approached this court by filing WPC number 2097 of 2017, whereby order dated 1/9/2023, the court had directed the respondents to a petitioner had earlier approached this court by filing WPC so-and-so on the ground that his candidature for appointment was rejected on the ground of the petitioner furnishing a driving license which was found to be fake. Stop. On the pleadings being exchanged before the court, this court by order dated 1/9/2023 disposed of the writ petition primarily on the averments made by the DTO Juneboto. Juneboto in the state of Nagaland, that the driving license issued was not fake and is a genuine driving license. So the respondents were therefore directed to consider the case of the petitioner in any available vacancies within the period of 1 year thereafter. Stop. The respondents filed a review, which subsequently came to be dismissed on 3009/2024. Filed a review being review petition 51 of 24, which subsequently came to be dismissed on 3009/24. Stop. So, the petitioner's representation was stood rejected on 14 November 2024 by the respondent authority, whereby it was stated that there is no vacant post of fireman as on 1/9/2023. And since no vacancy has arisen till date, the case of the petitioner could not be acceded to. Stop. The learned counsel for the petitioner submits that he has filed applications under RTI seeking the information, which has not been replied to on the ground by replied to by the PIO as on the ground by taking recourse to the statutory bar under section 24 within bracket 1 of the RTI Act 2005. Read with the second schedule to the Act. So the appeal filed before the first appellate authority was also rejected. So the petitioner has now approached this court on the basis of a submission, on the basis of his information that there were vacancies available during the period under consideration, during which the petitioner's case, in which the petitioner's case could have and ought to have been considered by the respondent authorities. So the learned counsel for the petitioner, however, submits that his information is as per the instructions of the petitioner, and there is no official communication received by the petitioner to show that vacancies arose. So under such circumstances, the learned counsel to the petitioner is permitted 3 weeks' time to complete his instructions as to the source of his information that vacancies arose during the period concerned. There are list again after 3 weeks. Mr. S.S. Roy will also obtain instructions in the matter for which sufficient copies of the writ petition be furnished to the council within 2 working days.
Maybe leadership. And petitioners, my lord, appeared in the examination for the post of constable GD. And in the physical measurement test, his height was earlier fine, my lord, 164.4. He filed repetition, my lord, and this honorable court directed to the petitioner to file an appeal. In appeal, my lord, his height was fine 164.5.
What is the required height?
165, my lord. But my lord, as per guidelines, my lord, 0.5 centimeter can be rounded up to the next, my lord, higher centimeter, my lord.
Yes, Mr. Roy,
And there is a,
As per guideline, it was there, Lordship.
it is there.
Yes.
and there is a order also, my lord, of Kolkata High Court, my lord, on similar circumstances, my lord.
Only thing is that, Lordship, this is after DME. Then review 0.5 is considered, but Lordship, Kolkata High Court, Lordship, it was held otherwise, Lordship.
You get instructions here.
Lordship.
Very
Other matter fixed on 14, my lord.
Let it
And
come on 14th, Lordship.
Counsel for the petitioner submits that the petitioner's claims for petitioner's selection to the post of Constable GD in Central Armed Police Forces was rejected as the height of the writ petitioner was found to be 164.5 centimeters as against the specified norms of 165 centimeters. So the learned counsel for the petitioner, however, submits that as per clause 2B of the uniform guidelines dated 2005-2015, where there is a difference of 0.5 centimeters, the same may be rounded off to the next
higher centimeter.
higher unit. So consequently, in view of the petitioner's height being measured at 164.5 centimeter, in terms of the uniform guidelines, it ought to have been accepted as 165 centimeters, in which case the writ petitioner ought to have been selected for appointment. The counsel for the petitioner has also pressed into service a judgment rendered by the Calcutta High Court in WPC
74.
WPA
2176 of 2025 and other connected matters. So, Mr. S.S. Roy is permitted to complete his instructions, for which sufficient extra copies be furnished by the counsel for the petitioner. Stop. It is submitted that similar matter is fixed on 14th November. Accordingly, let this matter also be listed on 14 November along with WPC
5906 of 25.
5906 of 25.
Obliged.
Matter pertains to order of dismissal, Lordship. The petitioner earlier approached this honorable court also. Actually, what happened, Lordship, after of the order of the dismissal, he prepared an appeal before the authority. But during pendency of the writ petition, the counsel representing the other side informed this honorable court that the appeal disposed of. We, with a liberty, we withdraw it and again we file it.
Heard Mr. V.P. Portable and his counsel to the petition. The present writ petitioner is before the court putting a challenge to the termination order dated 12/7/2024, issued by the disciplinary authority, imposing the measure penalty of dismissal from service on the petitioner, as well as the order dated 7/12/2024, passed by the appellate authority, confirming the order passed by the disciplinary authority. So it is submitted that the order of the disciplinary authority was passed in contravention of the rules of the Discipline and Appeal Rules 1964, besides being violative of natural justice and the parameters necessary for prescribed in law in respect of departmental proceedings. So Tara, who's appearing? MS N. Bhattacharya, additional senior government advocate, represents all the respondents, considering the issues involved. Let us issue rule, because records will have to be.
Yes, Lordship.
Issue rule. Call for the reports. Since the council, government council represents the respondents, notices are waived, extra copies be furnished within 1 week from today. Respondents may consider filing their affidavits, if so advised in the meantime. List after return of it.
In this case, the petitioner was working as block data manager, my lord. And page number 36 is the imprint order, whereby, my lord, a Facebook page was post was, my lord, inadvertently shared, my lord, and on the basis of this, his service is terminated. The grievance is that, my lord, without following the principle of natural justice, my lord, the similar judgment.
He is appointed as what?
Block data manager, my lord, in the National Health Mission, as a contractual, my lord. And he was working, my lord, on 27/7/25, my lord, he was terminated on the basis of an FIR lodged by a, my lord, a police officer, page number, my lord, FIR is there, page number 23, my lord. On the basis of that FIR, he was arrested. And due to arrest, my lord, he has been terminated, my lord. And the decision of this honorable court is there, my lord. Decision is that if termination, if arrest is there, my lord, then it is a stigmatic order, my lord, and principle of natural justice should be followed, my lord. A recent judgment of this honorable court is there, my lord. May I place, my lord? Same, my lord, they were arrested, my lord, and well, this honorable court directed for reinstatement, my lord.
Heard. Counsel for parties, the petition is before the court, challenging the termination order issued by the petitioner, by the department.
Page number
The
30.
petitioner was serving as what?
Block data manager.
Data manager on
Yes.
contractual basis under National Rural Health Mission. Stop. Because of he posted something.
He was posted as that block data manager. Yes, my lord, Facebook sharing, my lord, shared, my lord. Facebook
Because of
post.
some messages being shared or posted in the social media. Some FIR was lodged against the petitioner, pursuant to which he was arrested. Stop. Petitioner, however, was released on bail by the Court of Special Judge Hailakandi on 27/8/2025. Stop. The respondent authority, however, considering that the petitioner was taken into custody pursuant to the FIR's lodged, terminated him from service by the order dated 27/7/2025. Stop. It is the submission of the counsel to the petitioner that no opportunity of hearing or any show cause notice was issued to the petitioner. Stop. Being aggrieved, the present writ petition is filed. Counsel to the petitioner has also referred to and relied upon judgment passed by coordinate bench dated 25/2/2025 report in WPC 4061 of 2023. Para MS.A. Bora. Submits that she would like to obtain instructions in the matter, or we issue notice
Yes.
accordingly. We should notice written about 4 weeks. Since the standing council represents all the respondents. You represent District Health Society also? All the respondents, notices are waived, however, extra copies be furnished within a period of 1 week from today. List again after returnable date. Yes.
Well, till returnable date, my lord, that may be some protection regarding the post not to fill up, my lord. Otherwise, it will be infractuous.
Till the next date fixed, the post in which the petitioner was serving and from which he was terminated shall not be filled up by the NHL without leave of the court,
All right.
if not otherwise
Yes.
filled up in the meantime.
Yes, all right.
My pleasure, Your Lordship. Lordship, here are basically two issues. Number one, suspension has been extending without being any region order, without reinstating the person. Number two, disciplinary proceeding has been initiated on the identical facts based on the criminal charges, my lord. So, regarding continuance of the suspension, my lord, Ajay Shadri will come to rescue me, my lord. And regarding the disciplinary proceeding, my lord will please to find the first suspension order at page 36, my lord.
Ajay Chaudhary has come to your rescue. Why are you before the court?
My lord,
We'll have to rescue you.
definitely, my lord.
We'll hear you. Heard. Done counsel for parties, you should notice. Depend on the Mr. Ghosh appears on behalf of all.
Lordship,
I appear for 4.
Huh?
I appear for 4.
4.
4.
except for all, except for all.
1, 2, 3, 5, and 6. Mr. B. Sharma for responding.
4.
Since the issue pertains to the continued suspension of the petitioner and non-completion of the departmental proceedings,
Yes, my lord.
let the respondents complete their instructions in the matter.
And till then, my lord, departmental proceeding may be stayed
No.
because on identical facts, the criminal charges, criminal case has been going on, my lord. And on the same set of facts, my lord, because first the FIR was lost.
There is no prayer for interim.
My lord, I understand there was a mistake. There was a mistake on the part of the, but on the extraordinary jurisdiction, my lord, may issue at least.
Without satisfying, why should we stay it?
Yes, my lord,
We have
I'm
to satisfy ourselves that they're absolutely identical.
My lord, I'm
Would
coming to
be-
that. My lord, I'm coming to that. My lord, may first look at the suspension order at page 36.
No, not like this. Let them get their instructions. We'll examine the matter. What is the stage of departmental proceedings?
My lord, only notice, so cause has been issued and reply has been filed.
Then?
That may be stayed, my lord. Till then, my lord, till the returnable date, my lord.
When did you file your reply?
My lord, we have filed our reply on 21/6/2025, it's June.
6 months of, actually 6 months have already gone. Issue notice. Notice given, taken? Huh? Okay. Let the respondents complete their instructions and continuance of the disciplinary proceedings will be considered by the court and appropriate orders, if required, will be passed
My lord,
after the return of date.
much obliged.
My pleasure, Lordship. So the petitioner is agreed by order of suspension in the year 2023, he was suspended and thereafter he approached this honorable court. Lordship, annexure number 15, this honorable court was pleased to set aside the suspension order and directed the authority to reinstate me within 15 days from the date of receipt of a certified copy. Initially, I was posted in the office of the circle officer Hajo. Thereafter, after reinstatement, I was transferred to the Dhemaji. Without challenging the order passed by this honorable court, the respondent authority again suspended me for the same reason. Lordship will find in it is a reinstatement order in annexure 16. Thereafter, Lordship.
Now, this order was passed on 21/7,
Yes.
25.
Yes, and
Then-
5/9/2025, Lordship will find annexure number 18, page number 83. They again suspend me for the same. In a similar matter, the issue in a different case, a matter was placed before your Lordship. On 24/9/2025, your Lordship was pleased to issue notice and stay the impugn order, the second suspension, and immediately thereafter they reinstate the said person. The authority never approached any higher forum challenging the order passed by this honorable court for setting aside the suspension order.
Reasoning to ignore it. Where is the report received from the SP?
What were the charges earlier?
Same, for taking bribe. Allegation is there for taking.
Where
bribe.
does one find it? Where is the earlier charge sheet? Suspension order or charge sheet or whatever.
Suspension order, Lordship will find in page number 29, annexure 3.
29.
And annexure 5, page number 36, Lordship will find the so cause.
How does that over? এই রিপোর্টটো দেখিল তো ডাইরেক্টর এটা কেস বসে ফাইভ সাইজ দুটা বেলেগ বেলেগ নিয়ে
Where is that order you're relying on?
Same post, same department. my lord.
I do not know what was the subsequent order, subsequent suspension order in this matter that you're relying on?
But
The judgment that you're relying on, he
It's
was
a- it's a-
subsequently again suspended.
yes, similarly here also, same matter also. Here also, he was suspended for the second time.
You get your instructions, we know he is for suspended for the second time, we're asking you, what was the content of the suspension order? Second suspension order in this matter,
Lordship will find it,
in the judgment, in the order that you're referring.
Judgment.
It's not here. I heard Mr. Bhattakul done at counsel for the petition, Mr. CPS Borua for the respondents, the petition before this court is agreed by the order dated 5/9/2025, whereby the petitioner was placed under suspension pursuant to receipt of report from the Superintendent of Police Directorate of Vigilance and Anti-Corruption dated 8/5/2025 that the criminal case being ACB PS case number 38 of 2023 under section so and so is pending trial. Stop. Counsel for the petitioner submits that earlier the petitioner was suspended and which came to be challenged before the court by filing WPC number
next are 15, my lord. Page number 71, 6289, 2024,
page number
71.
WPC 6289/2024, which came to be disposed of on 21/7/2025, whereby the coordinate bench interfered with the suspension order and directed reinstatement of the petition. So it is the submission of the counsel to the petitioner that pursuant to the directions issued by this court, petitioner was reinstated in service. By order dated 7/8/2025. And posted at Gogamukh Revenue Circle. LA branch, DC's office, Dhemaji, Gogamukh. However, by the impugned order, the petitioner was again suspended. Stop. It is submitted that this subsequent suspension orders by the subsequent impugned suspension order was issued by the respondents on the same ground which was interfered with by a coordinate bench. Stop. Being agreed, the present petition has been filed. Mr. Borua.
For respondent numbers 2 and 4.
Appearing for 2 and 4.
Brother. 1 and 3.
Yes, for respondent 2 and 4. Mr. S. Dr. appears for respondent 1 and 3. Submits that they would like to complete their instructions. So, accordingly, that notice issue written number 4 weeks since the respondents are represented. Notice is waived. However, extra copies be furnished within a period of 1 week from today. Matter be listed again on on 12th of December. Till the next date fixed, the impugned order of suspension shall remain stay. As it appears to the court prima facie that the grounds on which the petitioner was suspended and which came to be interfered with by the judgment dated 21/7/2025, passed in WPC 6289 of 2024, and the impugned suspension order appear to be one and the same. And according to the petitioner, no appeal or review has been filed by the state against the same judgment and order dated 21/7/2025, passed in WPC 6289 of 2024. Continuation of the interim order will be considered again on the next general date list accordingly.
Pursuant to an advertisement dated 6/10/2023, petitioner applied for the post of cook. Selection was conducted without following the scheme of the selection as per the advertisement. Trade proficiency test was not taken, physical test was taken. Although the mandate is that trade proficiency test will be conducted, but he has only asked 3 questions, and thereafter result merit list has not been published, although advertisement said merit list will be public. And in the website, when it clicked his number, the result is shown that he has not been selected. So at my lord, coming to page 28, the candidates reporting candidates reporting at the venue on the
Para?
day, para C, page 28 of the advertisement. Page 28, advertisement, scheme of the examination.
Yes.
The candidates reporting at the venue on the date and time of her physical standard test and date affidavit, she must bring all the documents uploaded during submission online application mentioned at para 5, along with one set of self-attested postal and same for verification by the selection committee on the date of their PST and TPT trade proficiency test. Physical test conducted, trade proficiency not conducted. Then, my lord, I am coming to page 29. Serial number Roman 7, physical tender state and preliminary medical checkup trade proficiency test. After documents are found correct, the candidates will have to appear in the PST. It will carry no marks, measurement.
Let
of
them
the-
obtain instructions here.
Yes, my lord.
Right, Council Broker.
My lord, may I pray for an interim that vacancy one? If it is,
There, how many vacancies are there?
my lord, advertisement notifications, there are vacancies. My lord.
Ah.
The merit list was
26.
not published. My lord. Although mandate, selection mandate,
Let them get their instructions.
Instructions.
Give them a short date.
my lord,
Yes,
that is the, that will.
The learned counsel for the petitioner is aggrieved by the non-selection of the petitioner for the post of a cook under the Assam Police Headquarters in the recruitment for which was advertised by advertisement dated 6/10/2023. So the petitioner submits that he satisfies all the norms and had duly applied for the selection and appointment. However, while the select list was not published, the portal of the Assam Police Recruitment Board
Recruitment.
reflects that the petitioners, the roll number assigned to the writ petitioner reflects that he was not selected. He is not selected. So, being agreed, he has filed the present writ petition. Where MS U. Sharma, learned government advocate, appearing for all
respondents.
submits that she will obtain her instructions in the matter. Let these instructions be placed before the court on when? 19th?
Lordship.
Right.
19th.
19th.
Okay. Extra copies.
extra copies be furnished within the period of 2 working days from today.
Blessed.
May it please the Lord. Madam, the petitioner, while serving as the professor and HOD of pediatrics, Assam Medical College and Hospital, Dibrugarh, purported allegation on sexual harassment at workplace was lodged on 17/10/2022. No copy of the complaint was served as mandated by the
What
board.
is the stage of the inquiry?
My lord, now they have furnished me the impugned final inquiry report, which dates back 16/11/22, and it was served on, my lord, 22/8/2025.
Where is that order?
Lordship will find that annexure. Page 36, annexure 8, my lord.
Hmm.
I am assailing this order on the procedure. Each and every prescription under the act and the rules has been violated. The copy of the complaint was not furnished. The enquiry was done for, complaint was submitted on 17/10/2022. Next day hearing was conducted without furnishing the copy and concluded. And on 16/11/2022 report furnished. Now the report has been given to me on 22.
Did he approach the court earlier?
Yes, my lord, what happened during the pendency, I annexed that order. During the as there is a, my lord, procedure inquiry going on under the Sexual Harassment and Workplace Act, the department parallelly started a departmental inquiry that has, and imposed a penalty that has been straight, my lord. They cannot be, Medha Kotwal Lele says, my lord, it has to be the inquiry report of the internal committee. So here, my lord, the procedural irregularity is being challenged in.
You are challenging the final report.
Yes, because the inquiry report was, and complaint was not given. It was conducted on a single day. And my lord, after 2.5 years, this inquiry report is being furnished to me. And there are other procedural lapses also. So, my lord, today I am saying that lordship will issue notice, let them file their response, and in the meantime, it may be kept in abeyance, you know.
Why should we keep in abeyance? Just for the asking? Why?
No, my lord. My lord, if
Let them obtain their instructions. We
Yes.
issue notice on the state rate.
yes, my lord, yes.
Heard Mr. J. Patwari, learned counsel for the petitioner. And Mr. B.P. Pora, learned counsel appearing for the health department representing all the respondents. So petitioner is agreed by the final report of the internal committee submitted to the writ petitioner. On the inquiry conducted by the said committee in respect of allegations made against the writ petitioner, in respect of allegations leveled against the writ petitioner by the complainants under the provisions of Prevention of Sexual Harassment of Women at Workplace Act, so and so. So the counsel for the petitioner submits that the entire procedure prescribed under the rules have been completely flouted by the internal committee, and the inquiry was completed on 16/11/2022.
Yes, ma'am. The last page 37, only one of
The
them.
dates
Page 37.
seen in the inquiry report, and which was served to the petitioner only on 16/8/2024.
No, 22/8.
Huh? 16/8,
Issued on 16/8, I received it on 22/8.
and which the petitioner claims he has received it on 22/8/2025. Stop, it is submitted that had recommended that the allegations on having been found to be correct, the petitioner should not be allowed to abuse his authority by appointing him as HOD or in any senior position or as an NMC assessor. Stop. It is submitted by the learned counsel to the petitioner that pursuant to the inquiry report submitted, the disciplinary authority is likely to take, he apprehends that further decision, further steps will be taken by the disciplinary authority on this basis. It is submitted that since this report has been report has been submitted by the authority in total violation of the rules, the operation of the same be stayed until further orders. Mr. Bora, on the other end, submits that he would like to complete his instructions and file necessary affidavit in the matter. Considering the prayer made by the petitioner, issue notice on the stay prayer, returnable again on 12th December.
Yes.
Let this matter be listed on 12th December. Extra copies below.
Timing item 4.
My lord, I have been informed, my lord, Mr. Sutia is some, my lord, personal inconvenience. Mr. Dwar will, my lord, appear, and he told me that no instruction has been received. So, my lord, let notice be issued, my lord, otherwise there is a personal, a private respondent also.
Now, Mr. Dhor is also not appearing.
Yes.
Yes.
Next lordship.
Yeah.
Anyway, lordship, lordship may issue notice in this matter.
Third council for finance issue notice, returnable 4 weeks. MS M. Bhattacharya, the additional senior government advocate, it appears an accepts notice on behalf of respondent.
1 to 5 lordship.
Stop. Since the learned government advocate represents the respondents 1 to 5, notices are waived. Extra copies be furnished within a period of 1 week from today. Stop steps of respondent 6 by speed post within 1 week from today. The respondents may complete their instructions and file necessary affidavit.
Lordship.
In the meantime, list again after returnable date.
My lord, interim order pass may continue.
Interim order passed earlier will continue till the next date. List on 12th December.
Deeply obliged.
Deep progress.
List for motion item 33.
Hey, please, Lordship. My lord, this was VDP case and the petitioner has been removed from his service, from his post of VDP, that is the 79 Lordship can listen.
Yes.
79, sorry. 59, sorry, my lord, 59.
Yes.
Only two lines order. It is hereby the order that Sri P.R. Ali Sarkar, instead of Naushad Ali as VDP secretary of Durgamari VDP under Bongaigaon PS with effect from 29/5/25 without any reason. Now they have filed an affidavit that he demanded rupees 50,000 from an woman and on that ground he has been removed. But order does not say anything. It is completely afterthought. So kindly see how this SP is behaving. Their affidavit, they say, this petitioner demanded rupees 50,000 from a nomen, and during that, kindly see their affidavit, page 85, para 4. Nor the copy of this complete petition is submitted to the petitioner, nor he was asked to appear for any inquiry. So behind his back inquiry was completed and I don't know what is the inquiry, what is the complaint, and this order was passed in a totally different manner without any reason. So it appears that the officer has completely passed the order in violation of principle of national justice.
Which paragraph in the affidavit?
Page 85, para 4. Yes. And earlier, my lord, there was a review petition before the division bench, and division bench has upheld the order of my VTB secretaryship and set aside the order of the learned singles. That,
This is regarding a separate case, lordship.
yes, that was.
This is not pertinent because there are also other evidences, lordship, he misused his position. So these cases are reference to the earlier misdeeds of the petitioner, lordship.
Which case?
No, the
The page,
counsel that is
Let me-
referring to
let me
another
clarify
review
that.
case. review
There was
petition,
earlier a
lordship.
writ petition. That writ petition was decided in my favor. Then the private respondent came, file a review petition. In the review petition, the order of the landed single judge was, this landed single judge set aside his own order, that the order was passed legally. Then we challenged the matter before the division bench. Division bench said that the order passed under review by the landed single judge is record. So in that view, I was totally.
Government, you
Lordship.
produce the records.
Yes, lordship, we will be producing record.
Page number, para 4.
Yes, lordship.
Whatever statement.
Yes, lordship.
The records we placed before the court.
Yes.
It is called for the records. Find out what allegations and how it was.
Copies are not
inquired.
furnished to us.
Huh?
That is, copies are not furnished to us.
Therefore, we are calling for the records.
Yes.
A short date we fixed one.
Heard Minister and on MS M. Bhattacharya, learned additional senior government advocate for the state. The petitioner is agreed that he was removed from the post of village defense. What is that?
Organizer. Village Defense
Secretary
Organization.
Village Defense Organization. lord.
From the post of
Village
secretary.
Defense Organization. Stop. The removal was issued by the
By the Village Defense Organizer means SP. Bongaigaon.
by the
SP Bongaigaon.
competent authority on the basis that the allegations, there's certain allegations of acceptance of illegal gratification against the writ petitioner have been found to be correct. Stop. The respondents have filed an affidavit in opposition whereby at para 4 of the affidavit, these averments are made. Stop. However, these averments are not supported by the relevant records. Stop. In that view of the matter, let the records of the matter pertaining to the inquiry conducted against the writ petitioner in respect of these allegations be placed before the court.
But the impugn order does not say anything about all this.
Within 2 weeks.
Lordship will be.
Within 2 weeks. List again on 28th
Lordship.
November.
All right.
Lordship, I think this matter to be posted in admission column, Lordship.
Notice is issued here.
Yes, Lordship.
28.
No, Lordship, I think notice was not issued.
But then he will issue notice.
Lordship, yes, Lordship, may issue short notice.
Returnable for which.
Yes, Lordship, the private respondent is also there.
Then Ms. M. Bhattacharya represents all the respondents.
No, Lordship, 1 to 4, 5 is private respondent,
1
Lordship.
to 4. Notices are waived, however, extra copies we furnished. Steps on respondent 5 by speed post within 1 week from today. Then we will have to defer it.
Yes, Lordship.
List again on 12th December.
Lordship. Deeply obliged, Lordship.
34. Let me kindly tell you the last order, 3/11/2025. They're supposed to place on record
Where is the forest?
last occasion of the day.
Forest Standing Council.
Now, let me take it after some time and I'll inform someone.
Yes, after some time.
Obliged.
35.
May I please, Lordship? So in this case, we have received instruction, Lordship. But only one thing, Lordship, that during the pendency of the instant requisition, Lordship, the union has invoked the section 33 of the Industrial Dispute Act. Lordship, if take up the Industrial Dispute Act,
Industrial disputes.
section 33, Lordship. My book, page number 95. Because petitioner is a workman, Lordship. Condition of service, etc., to remain unchanged under the circumstances during pendency of the proceeding. During the pendency of the any condition proceeded before a conciliation officer or a board or any proceeding before an arbitrator or labor court or tribunal or national tribunal in respect of the industrial dispute, no employer shall, in regard to any matter connected with the dispute, alter to the prejudice of the workman concerned in such dispute the condition of service applicable to him immediately before the commencement of such proceeding. For any misconduct connected with the dispute, discharge or punished with.
Something has been filed before tribunal.
Yes, Lordship.
Labor court.
Yes, Lordship. Regional level commitment, Lordship. Notice also issued, Lordship.
Conciliation.
Yes. The first is the complaint, Lordship, and second is the notice issued to the Oil India Limited, Lordship. So, second page, Lordship, of the complaint, Lordship. Then especially Mr. Jadov Chandra Kolita, President Pipeline Branch, because he is the president and protected workman 5%, Lordship, as per section 33, Lordship. And accordingly, the union has raised this issue before the Regional Labour Commissioner and Regional Labour Court second, Lordship, phase. Lordship, notice was issued to the Oil India Limited to respond. So during the pendency of the this writ petition, Lordship, they has also approached the another forum, Lordship. So either they have to. So it's once forum, Lordship. Because in that proceeding also notice issued, Lordship.
Very well. We'll close it by saying that during pendency.
Yes, because he is the petitioner, he is the workman.
My lord, I pray for some time to obtain instructions, my lord.
You obtained
I'm
instruction.
totally in the dark, my lord.
You obtained instruction.
Yes, Lordship. I have.
You serve him a copy.
Yes.
The heard Mr. C. Chaudhary, Senior Chinmay Chaudhary, Senior Counsel, assisted by Mr. H. Sharma. And Mr. K. Kundita for the respondents. So, learned counsel for the respondents submits that during the pendency of the writ petition, the conciliation proceedings was initiated by the union
Yes.
for the workmen under
It-
the
Consider
oil-
Union has already invoked the section 33 Lordship. For the
under
regional.
Oil India, and has also sought for invocation of section 33 of the Industrial Disputes Act 1947. So it is submitted that under section 33, it is prescribed that during the pendency of any proceedings before any labor court or industrial tribunal or conciliation proceedings, conditions of service in respect of the employee shall not be altered. So the council therefore submits that since the workmen, the union of the workmen, in which the present petitioner is the President Pipeline Branch Oil, has already approached for conciliation proceedings before the
Regional Labor Commission.
Regional Labor
Regional Labor Commissioner Lordship. Notice was issued.
Commissioner, and for which notice has already been issued. The Learned Counsel for the respondent submits that the writ petition should be closed as the union representing the case of the writ petitioner has already approached the Regional Labor Commissioner for conciliatory proceedings. Para, Mr. Chaudhary, Learned Senior Counsel, on the other hand, submits that he be permitted to complete his instructions in this matter as he has not been permission to complete his instructions in the matter. At least again on how much time?
So that because interim order is operating. Lordship.
Not 1 week or 10 days.
21st November. Interim order passed early will continue till the next date fixed.
I'll apply.
Meet your lordship. This is the transformator for the disabled persons, my lord. They were supposed to place instructions, my lord, but
Lordship, today I have filed Wakalat number for respondent number 4, Lordship. His by name, he is arraigning as respondent number 4, Lordship. The Chief Inspector Boiler is already made party as respondent 2, Lordship. So I'm appearing for respondent number 4 and we will file affidavit, Lordship. So matter may be fixed on Friday, Lordship.
there is some other things, my lord. My lord, I was on leave. At the end of the leave, I joined my previous place, that is at Sibsagar. And the inspector there in Sibsagar, they have accepted my joining report. But on the same day itself, in the afternoon, it was again cancelled. Now I am nowhere. Neither they have paid my salary of the last month.
All right, you will.
Lordship, kindly take up the matter at 2, Lordship. My senior will.
No, we'll give you on, we'll take it up on Friday.
Yes, please. Till then, notes.
Friday.
Since the important aspect is this, my lord, lordship will appreciate that my joining letter has been rejected. Once it was accepted, given that at the instruction of the chief inspector.
You bring it on record. You bring it on record.
My lord. But the fact is this, just appreciate for a while. According to the last order, your lordship was pleased to grant that no coercive action shall be taken by the department. This is the coercive action. They have stopped my salary. This is a coercive action. They have refused to
So
accept
we'll
my.
have to examine this, Mr. Chamua.
My lord.
You bring it on record.
My lord.
MS
Peace over your Lordship.
E. Soria, Learned Counsel, submits that she has been instructed to appear on behalf of respondent number 5.
4, Lordship.
4.
Yes.
It is therefore, she submits that she'd like to complete her instructions and file an affidavit.
Yes, Lordship.
How much time?
Within 2 days, Lordship, I will file.
within 2 days. Better. Mr. Chumua on the other end, counsel for the petitioner on the other end, submits that notwithstanding the interim order granted on 31/10/2025, the petitioner's joining letter stood rejected
And salary had also not been.
and salary has also not been released. And as a consequence, the petitioner he has no place to join, has not been permitted to join in his place of posting, which is Sipsagar. Mr. Chomua is permitted to bring on record the additional documents which has been received by the writ petitioner. Stop. As agreed to, let the matter be listed again on 14th.
On
Ma-
Friday.
My lord, can it be on 13th?
No. We can have it on 17th, we can have it on 19th if you want.
Okay, 14th is all right, because this man is neither this way nor that way.
14th.
My lord, actually, today was, this the government has to place their stand,
Is government who's appearing?
I'm repairing my.
What do you say?
No, my lord, our instruction is limited. Of course, the instruction would come from respondent number 4 only. Since respondent number 4 is here.
Mr. Ard Hall, Leonard, government advocate representing respondents 1, 2, and 3. Submits that the orders impugned in the present writ petition are passed by the respondent number, the office of the respondent number 4, respondent number 3. And therefore, the instructions are awaited from the office of the respondent 4, respondent 3. But the respondent 3 is arrayed as arrayed by name as respondent number 4, and who is represented by the counsel appearing for the respondent number 4 today. So, in that view of the matter, as agreed to by the counsel for the parties, list again on 14th November.
My lord, can I take back the stupid?
Timing item 34.
I was getting worried.
Sorry, Lordship, I was legs a lot.
Why is Forest never here
Lordship,
in any matter? We'll have to request Forest Council.
I was in legs, I'm here short of men today, Your Lordship.
You're short of men, next time we'll be short of patience.
I'm sorry, Your Lordship. Lordship, take an instruction, the exact date of the next TPC sitting cannot be ascertained, Your Lordship, at this point of time. The next meeting of the TPC, it cannot be ascertained at this point of time. They cannot tell the exact date.
We don't say an exact date, but an estimated time frame. You can't.
That
keep it.
also can, that can be because.
Why?
Because DPC is, the officers has to be there for concluding the committee, Your Lordships. So estimated time will even also, Your Lordship. So at this stage, since notice has not been issued yet, let me take formal written instruction.
Well,
Your
I
Lordship.
heard learned
My lord,
counsel for parties.
my lord,
to
in-
notice.
In this regard, my lord, I have, because my lord, this case is pending since July, my lord, and they are taking time, my lord.
We're
Because
issuing notice.
the only thing, on last date, my lord, my lord, so please to observe that if they could not produce the exact date, my lord will pass an order giving a time.
We
frame, my
can
lord.
close it. There is no difficulty, but will it be proper to close the matter?
Otherwise, my
directly?
lord, they will, in next time also, they will come to same.
Mr. Counsel, please understand.
Because issuance of notice.
What does the rule say regarding constitution of DPCs?
But regarding rule, my lord, because this is a review DPC, my lord. In fact, they have already circulated the convened the meeting, my lord. But on that day, due to some reasons, that could not be held, my lord. Now, my lord, they are not conducting the review DPC, my lord. My lord, will kindly.
Where is the order for conducting review DPCs?
Yes, my lord. Page 27, my lord. Relevant portion at page 28. In view of the above, since his immediate junior, Mr. So-and-so, along with his 8 more junior, were already promoted to rank of DCF by government notification dated so-and-so. Therefore, Sri Robin Kumar Boiso, so-and-so may be considered for promotion to the rank of DCF with retroactive effect as paid for. Thereafter, my lord, this is the notification giving retrospective promotion. Then his seniority was fixed before Uttamananda Goswami, page 30. Then, my lord, selection committee meeting, page 31. This is 2nd January, my lord. Selection committee meeting for promotion of of officers to the rank of Deputy Conservator Forest from the rank of Assistant Conservator Forest, so and so, to be held on 3/1/2025 at noon 12, my lord. Thereafter, my lord, on that day, due to some reason, it was not held. But thereafter, they are delaying it, my lord. As regards the instruction also, my lord, they are delaying it, my lord. Because I am not there.
The 3/1/2025, the minute says that your lordship, they were, after exam record, selection committee found that there is lack of sufficient document to consider all the existing vacant posts to DCF, your
We
lordship.
bring it on record.
Very well, lordship.
All the, because this is for me only, my lord, not for the others, my lord.
We bring it on record within 1 week. On record within 1 week. Heard Mr. N.J. Khatoni, counsel for the petitioner, Mr. R.R. Gogoi, representing the Forest Department. Mr. Gogoi will file affidavit as prayed for. Mr. Gogoi will file an affidavit to bring on record the reasons as to why the selection committee meeting for promotion of officers to the rank of Deputy Conservator of Forests, which was scheduled to be held on 3/1/2025, would not be held. And as to when the said meeting is scheduled to be held, is now scheduled to be held. Stop the claim of the writ petitioner. The writ petitioner claims that it is a review selection committee meeting for promotion for consideration of the case of the writ petitioner.
Petitioner only, my lord, not for others, my lord.
Where do you say that?
Because I was the only person I left out, my lord, but others, all of my juniors are.
As the writ petitioner is the only person left out from his feeder category of what? Conservator.
Is ACF, my lord, from ACF.
Assistant Conservator of Forest. As all
And-
other members, including his juniors.
9 juniors, my lord, my 9 juniors were promoted.
Have been promoted to the next higher post. Therefore, the claim of the petitioner is required to be redressed at an early date by the respondent.
They are now, respondents are now trying to club my case with the others, my lord, who are much more junior to me, my lord. Not in the same gradation list. Nothing but a delaying tactics, my lord.
List began on 28th November. The respondent will file the affidavit as directed by.
In
this
that
court.
case, my lord, madam, I issue notice also, my lord, because since 28 is, today is, my lord, 10th. Because on that day, they will again ask for, my lord, may issue notice.
We said we'll issue notice.
Since, my lord, I thought, my lord, date will be a little early, my lord, that is why.
No, early date we can give provided the affidavit is filed.
Let notice go, lordship will file the affidavit by 28th.
Considering the submissions made, let notice issue returnable on 28th of November. So the Mr. Gogoi represents all the respondents, therefore notices are waived, however extra copies will be furnished within the course of the day.
Yes, ma'am.
Yes.
Lovely.
Don't tell us that you have not been able to serve copies during the
No,
course
no,
of the day.
No, my lord. In fact, my lord, may give, if they can file it before 28th, so in that case, I can
Let
file
them
it.
at least file it by 28th.
Oblige, lordship.
For order that is 16.
Please, your lordship. Lordship, in this matter, services are not complete for the private respondents number 7 to 10, lordship. Lordship, they are active members who are serving in the force. That's why, lordship, the proper address is not found, lordship. Lordship, I may be allowed to serve for the respondent number 5, lordship. To serve notice.
Who is for the respondents? CGC.
Yes, lordship. CGC.
Where is the CGC? You are permitted to file affidavit in reply, you did not file.
Lordship, perhaps that will not be required, Lordship. It may come for admission hearing, Lordship. Matter relates to the appointment of the petitioner to the post of constable driver.
You get hold of a CGC,
Lordship,
CGC.
obliged.
Item 17.
None appears for the petitioner on called. None had appeared for the petitioner when the matter was called earlier on. 8/9/25. Office note dated 14/7/25 reflects that steps for issuance of notice on respondent number 5 have also not been received by the registry. That it appears that the writ petitioner is not interested in pursuing the writ petition any further. Accordingly, writ petition stands dismissed for non-prosecution. Interim orders, if any, stand vacated.
18.
May I please, Your Lordship? Lordship, regarding this matter, all steps are completed and accordingly we have filed the amended cost title. And matter may come up for admission.
It is submitted by the counsel for the petitioner that service is complete on all respondents and the amended course title as permitted has also been filed before the registry. Accordingly, matter be listed for admission in the month of December on a date to be fixed by the registry. MS Kempra appears for Karbi Anglong. Yes.
Obliged.
19.
In this case, we have taken steps.
Hmm?
We have taken steps on my lord.
You have taken steps.
Yes,
By Dusty.
5/7/2021
No, no, how? By Dusty.
by registered person.
It is submitted by the 5/7
5/7 my lord.
by registered post.
Yes, my lord. Well, sorry, my lord, 27 is that, my lord, 27/7/2021, my lord.
Office note dated 15/7 reflects that
It is
ID
acknowledgement.
card and unserved notice has not been received. You had appeared and prayed before the Lozima court for taking steps by Dusty.
Yes, my lord.
Have you taken by Dusty?
Acknowledgement. Dusty, my lord, she's not found, my lord. So her address, I do not know, my lord.
Then what?
She's the, my lord, third wife of the, my lord,
Then you'll have to take steps by substituted means.
my lord.
What do you want to do?
Well, I take step then, my lord.
Steps on respondent 6 have been found to be not complete by the Lozima court. Stop petitioner is permitted to take steps. Fresh steps on respondent number 6. Within 2 weeks from today. Yes, list after 2 weeks. Yes. No.
Item 22.
Your Lordship, as per office notes, till date, no ID card or unserved notice Received that.
AD card not received. 6 to 8.
And I'm appearing for respondent number 8, Your Lordship.
8.
Yes.
You have to take fresh steps.
Yes, madam.
Respondent 6 and 7.
Yes, madam.
As per office note, steps on respondent 6, 7, 8 are not complete. Stop. Mr.
A. Chaudhary appearing on behalf of R. Sharma.
Mr. H. Chaudhary appearing on behalf of Mr. R. Sharma appears for respondent number 8.
8.
Stop. Petitioner is therefore permitted to take fresh steps by registered post on respondent 6 and 7 at the correct address. List this matter again after 3 weeks.
Madam.
23.
Please, Your Lordship, as per the office note dated 25/10 copy, service of notice was received for incomplete address perhaps, Lordship.
MM Potoki appears for the veterinary.
Animal husbandry and veterinary department.
And who else appears?
Lordship, I'm appearing for the treasury officer.
Mr. H. Aliha for the treasury officer, Mr. B. Chakraborty appears for the respondent number 3. Office, para office note dated 29/10/25 reflects that unserved notice through speed post was received with the endorsement within quotes insufficient address. So, however, none represents the writ petitioner today. When the matter is called up, list again next week. After a week.
Okay.
25.
Lordship, Lordship, in this matter, we had received a proposal from the PNRD, Lordship. Here, regarding his date of engagement, Lordship, there were 2 dates available, Lordship. So we have just written to the PNRD to give us the necessary documents to clarify whether on which date they have. One date is post FRBM, one is pre FRBM, Lordship. So only that clarification I'll need from my senior.
Yes, PNRD.
I have to take instruction.
Yes, Lordship. That is a clarification, Lordship, that once it's furnished.
Because it is it is addressed to the PNRD on 17 October.
27th October. This is 27th October, Lordship. So sometime may be granted, Lordship. We'll coordinate and Lordship.
You're Mr.
GG Gogoi.
GG Gogoi appears for the writ petitioner. Mr. H. Aliha submits that the papers received from the Department of PNRD.
Yes, Lordship.
From the PNRD department.
Lordship.
PNR department. It was found that there were 2 dates of appointment.
Yes, 2 engagement dates. Yes.
Engagement dates in respect of the writ petitioner. And therefore clarification is sought for from the PNR department as to the correct date of engagement. Stop. There are Mr. Additional AG for the state appearing for the PNR department submits that he would like to complete his instructions in this regard. Accordingly, list again after how much time? 2 weeks.
2 weeks.
2 weeks. He listed after.
26. Apply.
Probably, Your Lordship. Lordship, notice to the respondent number 7 has been served by Dusty Service Lordship. Affidavit has been filed. The matter may come of admission, Lordship.
The counsel for the petitioner submits that steps by Dusty has been undertaken and an affidavit of compliance to that effect has been filed. Which respondent?
Respondent number 7, Lordship.
7. The reverse side of the notice accompanying the affidavit reflects the endorsement stated to have been made by the respondent number 7. In that view of the matter, service on respondent number 7 can be deemed to be complete. However, none represents the respondent number 7 as on date. MS U Sharma appears for respondent number 1. 1 and 5, Mr. H. Aliha for 2. And MS Borua for? Bora for?
3, 4,
3, 4,
3, 4, and
6. 3, 4, and 6. Let this matter be listed for admission after 2 weeks.
Obliged.
Respondents in the meantime may complete their instructions and file necessary affidavit.
Obliged.
27.
Please, Lordship. But my lord, this matter is Lordship not non-compliance of order, court's order, Lordship. Lordship, so far my instruction, Lordship, steps have been taken by the contempt number, Lordship, 2 and 3, Lordship. And it is pending, Lordship, before the finance department.
AD card is not received as per the office note.
But Lordship, they have, if your Lordship kindly have a look at my instruction. I have received a copy, Lordship.
From
Lordship, the joint secretary, Lordship.
you bring it on record.
They have
Bring it on
received,
record.
Lordship.
You bring it on record.
Lordship,
You bring it on record.
Lordship, Lordship.
Office note dated 2006-25 reflects that AD card or unserved notice has not been received back for respondents 1 and 3. The counsel for the petitioner, however, submits that he has received some communication from the respondent department, which reflects that copies have been, notices were served on the said respondents. He is permitted to bring those communications on record by way of additional affidavit. And Mr. H. Oliha appears for respondent number 2. List again after 2 weeks.
That may be fixed, Lordship.
2 weeks. You file it first.
Lordship, obliged.
Time being, I think 16.
Suppose 16 বললে এটা কি হলো? ওইটা হইল 28 to কি হলো? কেমন করেছি? আমার পরে 16. Yes.
Lordship, I have informed Ms. B. Sharma. She left, Lordship. Lordship may place it on other day. In the meantime, I will serve a copy to her also, Lordship.
Who is P. Sharma?
Ms. B. Sharma, Vijita Sharma. Please.
Okay. And the request made by the counsel for the petitioner matter be listed after 1 week.
Obliged.
For admission, I think 29 to 32.
Made, please, Lordship. No, this petition.
We
is
had passed an order
Lordship, we have.
that day, but then subsequently there were few orders or judgments which were referred to. I do not know if it is here. But what was troubling us is that once an order of winding up is passed by the NCLT, now allowing you to open arbitration matters, we delay the process of winding up.
No, my lord, permissible, Lordship. Lordship, may kindly see, well, pending proceeding can proceed, my lord. Second, any proceeding which is for the benefit of the
No,
corporate.
this is not a pending proceeding.
This is a pending proceeding.
How?
Lordship will satisfy that order. Lordship may take up, kindly take up the arbitration act, section 21.
Arbitration Act.
Section 21.
Yes.
Lordship, section 21, commencement of arbitral proceeding. Unless otherwise agreed by the parties, the arbitral proceeding in respect of a particular dispute
commences on the date on which a request for that dispute has to be referred to arbitration is received by the respondent. Now, this is 2019 or 20, my lord, and insolvency proceeding started in the.
No, you
2020.
show us the order of compulsory winding up.
Lordship. That
Where
is,
is that?
Lordship, the petition that we have filed for appointment of the arbitrator. There is a miscase, my lord.
Miscase.
Miscase, yes, for
Miscase.
substitution of the arbitrator, my lord. Let me get that thing.
Page number.
Lordship, make a leave, lord. Lordship, may kindly see page number 14, my lord. Order dated 26/8/2021. You will also see the order date, my lord.
Page number 14.
14, my lord. Order dated is 26/8/2021. Now, in the order, if your lordship comes, kindly peruse, my lord. Paragraph, page 15, para 1. The present IB petition is filed by the financial creditor.
Page 15.
Page 15, paragraph 1, my lord. Last paragraph. The present IB petition is filed by the financial creditor, that is the State Bank of India, under section 7 of the Insolvency Bankruptcy Code 2016. Herein referred to the court seeking initiation of the corporate insolvency resolution. So this was the first day when this process started, my lord. 26.
This was for appointment of a resolution professional.
Resolution professional, my lord. After appointment, the resolution plan failed. Thereafter, liquidator was appointed, my lord.
So where is that order?
Lordship, the order is, my lord, that second order is starts from page 45, my lord. Order sheet on hearing on 11 December 2023, 10:30 AM. And the relevant portion would be, my lord. If you lordship at page 45.
Page?
Page 45, my lord. Order sheet of the hearing 11 December 2023, 10:30 AM. First, from National Company Law Board, next line, lordship. And the relevant portion is at page 50, my lord. As aforesaid, I number so and so is allowed with the following direction. The corporate debtor Nayak Infrastructure Private Limited is ordered to be liquidated with immediate effect under section 32(6). Very first one.
No, that's right.
So, my lord, here we have initiated the arbitration proceeding, my lord. In the notice was given, lordship.
See, you come to page number 51.
Lordship.
Clause 8.
Lordship. Clause 8. On initiation of liquidation process, but subject to section 52 of the code, no suit or other legal proceedings shall be instituted by or against the corporate debtor, save and except with the liberty of the liquidator to institute a suit or other legal proceeding on behalf of the corporate debtor with prior approval of the adjudicative authority as provided in section 33(5) of the code. Lordship, may kindly take section 33(5) for a moment, my lord, of the insolvency code. My lord.
Insolvency code, isn't it? Bankruptcy insolvency code.
We have confirmed it was there, lordship.
30?
Section 33, subsection 5, lordship. Lordship has it.
Yes.
subject to section 52, Lordship has been, when a liquidation order has been passed, no suit or other legal proceeding shall be instituted by or against the corporate debtor, provided there is no bar, Lordship can see, for the existing suit. Institution is barred, my lord. Provided that a suit or other legal proceeding may be instituted by the liquidator on behalf of the corporate debtor with the prior approval of the adjudicating authority.
Who is the adjudicating authority?
NCLT, Lordship.
Ah,
But that is only if I want to institute a fresh suit.
no. A suit or other legal proceedings,
Lordship,
whether.
institution,
it is
no
restricted
suit
or
or
the-
other legal process shall be
No,
instituted.
see, the issue is very simple.
Lordship.
You have appointed a resolution professional. Resolution professional has taken over the board, wanted to revive the company, everything failed.
That's it.
The reason being that the assets are well below the liabilities and you cannot pay it. So therefore, there's an order for closure, liquidation of the company. Once the process of liquidation starts and you initiate a simultaneous arbitration proceedings, tomorrow, if there is some amount found to be payable to the company, your entire basis for proceeding for liquidation maybe call for a review. Because you are now getting, say, a fresh claim.
Yes.
Which could have been used to revamp the company or pay off the debts.
Now, the whole liquidation process, Lord, is for the benefit of the company, my
But
lord.
that's all right. So these are things you should urge before the NCLT.
No, my lord. Lordship, subject to correction, my lord. Lordship, may kindly see section 14 for a moment, my lord.
Of?
It's of IBC code, my lord, 2016. Section 14. There is a difference, my lord. The moment an insolvency professional is appointed, my lord, all legal proceedings are barred. But here, Lordship will see even pending suits are stayed, my lord. Section 33, Lordship has seen the difference, there is no pending suit. And there are judgment of the different high court, my lord, supporting my assertion, my lord. Section 14, moratorium. Subject to the provision of subsection 2 and 3 on the insolvency commencement date, my lord. The first order that the adjudicating authority shall by order declare moratorium for prohibiting all the following, namely the institution of the suit or continuation of the pending suit. Lordship can see 33, this is not there, continuation is not there. Or proceeding against the corporate debtor, including execution of any judgment, decree or order in any court of law, tribunal, arbitration panel or other authority.
No, this will require some hearing.
It will require hearing.
It will require hearing. Therefore, we have to recall the order.
That's it.
It's a very simple policy. See, now you are getting the money.
That's it.
Assuming you get the money.
That's it.
What are you going to do with it?
We have to distribute it to the person creditors, my lord, who is.
Hypothetically,
That's it.
you receive sufficient amount
That's it.
to pay off the creditors without even selling off the assets. What happens then?
Then also, my lord, it will remain with the company and the creditors, my lord.
Where's
The
the
rest will
company?
go to the owner, my lord.
No, where's the company?
The
It's already
company,
on liquidation.
the directors will receive the rest of the amount, my lord.
How? You're a company on liquidation.
Then also it will, this process will, I will satisfy, there's some judgment we have given Lordship can produce that, my lord. The Delhi High Court, Madras High Court and the Bombay High Court.
We have the Delhi High Court judgments also.
Yes, Lordship.
This will require some hearing.
Lordship.
Because prima facie view is that you ought to have taken permission from the NCLT.
That is required in the, my lord, only when institution of fresh suit. That law is very clear. Lordship can see the difference, my lord. Moratorium under section 14 and moratorium under section 33. In section 14, there is no such.
We'll examine that.
Lordship.
Matter be listed again on
Next Tuesday, Lordship, if Lordship.
Tuesday is not possible.
Any Tuesday, my lord, when that Lordship.
27th,
27, Lordship.
Thursday,
Lordship. On 27.
27 November.
27 November.
You're Mr.
HP Gwala for Mr.
HP Gwala
BK.
for?
Mr. BK Das.
For which? For whom?
Railway.
For railway. Okay. Appearing for the railways. You are appearing
On behalf of my senior, Dr. Kiran Gogoi.
I am item
for?
Item number 30.
Huh? For railways.
Yes.
Okay. So three different councils in three different matters. How many matters are there?
4 matters.
So who appears for the fourth matter? 32 and
I'm
30, item number 30.
30 and
29, my lord.
and who appears for 31?
That one is Gupta, he is not.
नाम केटा लिखी लो 29, 30, 30